Yes, Mr. Bremner.
Lord, my ladies, good morning. Just two short points of housekeeping, if I may, before I continue with the IFA and promoter fees. The first is that yesterday my Lady Justice Falk requested a copy of the intercreditor deed relating to the LLP.
Yeah.
What we've done is gather copies of the 3 intercreditor deeds supplied as a soft copy overnight, and there is a hard copy of the LLP intercreditor deed, which is the one that wasn't in the bundle that's on the bench.
I mean, I've only looked at one of them. They all look pretty similar.
I'm not proposing to say anything about it in my submissions, but it's there if you would like to just to see it.
All right.
The second point is just to pick up very briefly on an exchange yesterday between my Lady Justice Falk and my learned friend Mr. Gammy, where reference was made to on the construction of and on the provision of language in other places in the Capital Allowances Act. My learned friend said he was sure there was authority on the relationship between the two. We did have a think about it overnight. I think the authority that was in mind was actually Mr. Justice Brightman in the High Court in Benedico. It's not in the bundles. I can either simply give you the reference, or we have copies if you'd like to see it. But it's Benedico High Court, 1978 Simons Tax Cases, 111. The passage is page 120, letter F, letter H, and also page 118, G, for the Crown's argument. I mean, entirely my ladies has it. If you'd like to see it, we have copies, and otherwise the references are...
Have you got them with you in court here?
Yes.
Well then, please, yes, I would like to have that.
What I'll do is just carry, because it's got nothing to do with what I'm proposing to say, but I'd like to be in moment
Yes.
to supply us. I'm very grateful. Yesterday, I had been developing the correct analysis on the IFA fees. I've got pretty much to the end of it. I've just been about to start on the promoter fees.
Right.
I'm very short indeed on those, because as you have seen from paragraph 60 in our skeleton, we say it's the same point, it's the same analysis. So there are 2 different types of fees. There are IFA fees, there are promoter fees, but in nature there's the same issues arising in relation to the promoter fee. That's the payment by OVL to Downing for Downing services and preparing and issuing the information memorandum. But it's the same point, it's part of the cost raising the finance. So I'm not going to go over that again. The promoter fees in my submission, they stand or fall with the IFA fees. So with the court's permission, if I may then turn to address you on the revenues primary case and make my submissions in response to that. The heart of the revenues primary case is what they say is that their interpretation of legislation. So this is put as a point of law on how you interpret the notion of expenditure incurred in connection with conversion. And it was said in their skeletons, their paragraph 67, and the point was reiterated orally yesterday, that Parliament intended to grant relief in respect of expenditure which is a natural, conventional, real-world association or connection with the renovation, conversion, incidental repair of a building. That's the proposition. It's then asserted that IFA and promoter fees, they have no such natural, real-world connection. That's the way it's put in the skeleton. Orally, that was maintained. It was also put, the logical report, in terms of remoteness. And my submission, actually, they aren't really 2 separate points. It all ultimately comes down to the same complaint. This is not the sort of thing with which this legislation is concerned. Now, in my submission, that approach to the legislation relies upon applying an impermissible gloss to the words that Parliament has enacted. It doesn't pay sufficient heed to the statutory context. In particular, it fails to give due weight to the fact that Parliament has broadened the test beyond expenditure on the conversion itself. So clearly, expenditure on the conversion counts, but so too expressly does expenditure in connection with the conversion. That's a deliberate choice done to broaden the entitlement to capital allowances. And even the revenue does not say it is only physical works that count. Now, if one asks, well, in conversion, it's in connection with the conversion, etc. Conversion is simply a reference to the process that has to be undertaken. You start with a qualifying building, so that the disused building that fulfills the conditions, and you then need to end up with qualifying business premises, so that the qualifying building is now used, or it's available and suitable for letting for use in the prescribed way. And what Parliament is telling us is that all expenditure that's incurred in connection with that process, that counts. And it's wrong in my submission to try to say, as the Revenue said below, well, it's only physical works, or it's only works that have a close link to physical works. You recall that was the point deprecated by the Upper Tribunal. That's now been slightly reframed before this court with an epithet of real world or conventional.
Well, I think it's common ground that in connection with is broader than on. The question is, how much broader? And as we know from commentary waste, it's a protean phrase, heavily dependent on context. I think probably you would accept that there is a limit to what falls within in connection with. The question is, where do you draw the line?
And my starting point in responding to the revenues case is to say that this case is a different one to commentary waste, because your Lordship will have well in mind that actually in that case, because of the context, the regulatory context, other provisions in that legislation, the explanatory note, I'm not proposing to take you through the detail of that, but actually it was really quite a narrow construction indeed that was given to
Yes.
what the perfect knowledge in terms was that actually in many cases, one doesn't necessarily want to get into synonyms, but he said in terms that substituting, I think it's having to do with, actually might solve the problem.
Yes, he did, but not in that case.
No, it didn't in that case, indeed. But the reason it didn't in that case was because of those very particular items of context that justified the narrower reading. We don't have any such items of context here. So I fully accept the phrase is not limitless. It's not anything at all that is going on at the same time as the conversion is happening, for example. There has to be a factual link, but the legislation is not prescriptive about what that link is. And in those circumstances, in my submission, there is a very heavy element of factual context and of evaluation. It's been left to the trier of fact to determine whether actually we have a sufficiently close connection or not.
Right, so the point is that this is a question for the fact finder, and an appellate tribunal whose jurisdiction is limited to points of law should not be interfering with that evaluation.
Subject to the usual limits. So of course, as one can see in Barclays Bank, if something is identified as being in connection with which is simply not capable on any view, then one would say that justifies intervention. That's effectively a Lewison type approach. If one put it in terms of trade, which is the setting of Lewison, is the activity capable of amounting to trade or not? Well, if it is, at that point, it's up to the first year to see if it's in or if it's out. That's one possibility. The other possibility, as Justice Lewison will be well aware from cases like Cheshire Cavity, is if one's into evaluation, is there some form of error of principle? So did something go wrong at that earlier stage, in which case, again, it might justify intervening. What one cannot, in my submission, do is to say, under the guise of construction, oh, well, it's something that is real world or something conventional, and then for the appellate court to substitute its own views of what counts as real world or conventional. It's no different, actually, to what one does if one looks at appeals in the context of whether the facts were viewed realistically. What one asks, did the tribunal below view the facts realistically? If it did, that's the reason. If it didn't, that would be an error of approach. But one can't, as an appellate court, say, well, my realistic view of the facts is different from the tribunal's realistic view.
Yeah.
So that, in my submission, is the approach, and Lewis' primary case runs hard up against that approach in my respective submission. I said it didn't give enough weight to that expansion beyond on it also, my submission, doesn't give enough weight to the specific exclusions in section 360B sub 3. We're looking at legislative context. It's highly relevant in my submission that Parliament has identified particular items of expenditure which it has said are not to count. And it's also, at least just of some interest, that it's the Treasury that's given the specific rulemaking power, I think it's 360B sub 4, to cut down expenditure, counting as in connection with, that's a power given to the Treasury. So that's the general point. The other point, which is a textual point, is if you have a letter friend's skeleton for their appeal, they made the general observation about natural, conventional, real world.
Sorry, where are you in the skeleton?
Oh, I'm so sorry. I'm in paragraph 67 of the Revenue's appeal skeleton. Which is in the core bundle, page 41.
Yes.
And I've principally been addressing the point that's trailed at the beginning of that paragraph. But I simply note, before leaving this point, the final sentence, and this is a textual as well as a contextual. What the Revenue has to do, because this is the next step, is to say accordingly the expenditure is too remote from, or not sufficiently connected or proximate to, the works of conversion. You have to interpolate the works of conversion. Now, of course, that concept is absent from section 360B sub 1. There is no concept of works of conversion, renovation, incidental repair. So in my submission, there's nothing in text, in principle, or in...
Well, repair must be work, isn't it?
Oh, well, repair it is, but that's an add-on, because it's repair insofar as related to conversion or renovation, so repair doesn't advance the point.
Right.
So if we're looking specifically at the IFA and the promoted fees, we're in a context where we've got legislation deliberately broadly framed, designed to encourage taxpayers to spend money in ways that relate to the conversion of disused buildings into useful buildings. There is, in my submission, no good reason, either in text or in principle, for disallowing the costs of obtaining finance. And there's certainly no good reason for distinguishing between the costs of obtaining debt finance on the one hand, which, as I said yesterday, the Revenue evidently accepts qualifies, and the costs of equity finance, which it said does not qualify. Now, I said yesterday that 3 reasons were advanced already by my learned friend Mr. Macklin to try to draw that distinction. The 3 reasons were these, and can I just set them out and then address them? The first was it said that the bank fee, that was for finance and finance only. Some mention of, well, being invited to join a club. I think it was the way in which it was put. That was said to differentiate IFA fees from the bank arrangement fee. Secondly was the amount being paid, which came down to saying that the IFA fees are bigger than the bank arrangement fee. And the third was it was said that bank loans are a common feature of renovations, conversions, IFA fees are not. None of those 3 matters goes to the nature of the conversion. So the nature of the connection. None of those 3 matters gives the court a principal basis for distinguishing between debt finance on the one hand and equity finance on the other. So in my submission, the point that was made in our skeleton, that the 2 matters cannot sensibly be distinguished, it has not been answered in any way adequately. It was also notable in my submission that on being asked a question about, or what about, say, a capital raising exercise, I think was the question that my Lord and the Chair put to the learned friend Mr. Mack, the response was, well, in my submission, the unprincipled nature of the distinction that's being sought to be drawn here. So no good basis for making that distinction. The other way in which the revenue put their primary case, and this was in the appeal skeleton of paragraph 70, is to say that the IFA and promoter fees, they're concerned exclusively with setting up the structure. So they say, just look at the limited liability partnership. It's all to do with establishing an LLP. That's what it's in connection with. I say that's not a tenable view of the factual picture here. The whole purpose of having the equity finance is to have funds to undertake the project. If you stop the analysis with the LLP, it's a bit like if one looks at a computer monitor looking at only some of the pixels on the screen. You're only seeing some of the picture. On any sensible view of the facts, what's being done here is fees are being incurred in order to raise the funds to go and get the project done. In oral submissions, it was said, well, building on this misguided point in the submission, well, they're not directly connected to the conversion, they're not exclusively connected to the conversion. They don't have to be. And we so embark is back. There can be a range of links. A given item can be connected with more than one thing. So that's not an answer. It was also said, and this is going back to the point about real-world conventional understanding of in connection with. After that submission was made about structure, it was said the legislation, as most fiscal legislation, is interested in economic activity in the real world. And there seemed to be a suggestion that somehow that wasn't what we were dealing with when we looked at the IFA and promoter fees. I say that point can't get off the ground. Of course, these are real-world transactions. Conversions are a real-world exercise. It had to be financed. It had to be paid for. There was also mention at this point in the oral submissions on what Mr. Douglas Smith, who'd given expert evidence for the LLP, had said about something called the Argus package.
Yes.
Your Lordship will recall that, and you were taken to some of Mr. Smith's evidence. You were shown his paragraphs 4.74 to 4.76. The burden of that evidence was that, of course, in arrangements like these, it was conventional that the developer would meet the cost and would take account of that in pricing the job, if I can put it in that colloquial way. He also showed you Mr. Smith's oral evidence. We saw there Mr. Smith was clear that Argos, that wasn't suitable in his view for a tax incentivized development. He's absolutely right about that. Malenfriend also touched on the evidence of Mr. Williams, who gave an expert evidence for the revenue. I simply make one observation about that evidence, which is that if one turns out 9.6.3, which is in the supplementary bundle, so it's page 722, but let me just
So that will be what, volume 3?
Yes, I think it is. Just give me 1 second. I will be able to be more precise about that. It's tab 55, which is volume 3. Very good.
Tab 55, yeah.
And it's page 722. I can't remember whether you were shown this or whether
Yes.
it was read out. I just note that Mr. Williams introduces his comment on the IFN promotion fees by saying this: I am not qualified to comment on the IFA and promotion fees. That's the first line of 9.6.3. So we shouldn't really be looking at what Mr. Williams had to say, given his own observation about his expertise. Sticking with the response to the revenues case, there were certain specific errors, which I suppose one might say of an ancillary nature that came later in the development of the submission. These are the points picked up in paragraph 72 in the revenues appeals schedule. They were dealt with already yesterday morning. Yes. And there are essentially 3. Can I just deal with those in turn? said, first of all, that there's an error in construction in allowing IFA and promoter fees to qualify. And I've dealt with that point already. That's the wrong way of looking at this. Once they're capable of qualifying, it's a matter for evaluation. That's for the tribunals, but not for this field. Secondly, there were criticisms of the Upper Tribunal's observations about the nature of the equity finance, which is set out in Upper Tribunal paragraph 285, which is in the core bundle, I think page 230, but it might be page 231.
Yes.
So the first complaint is about the observation that the conversion of Lush House would naturally have required equity investment. There's nothing in that. The Upper Tribunal is well aware that many BPRA claims would be small. They're just saying, given the size of this project, there's nothing surprising about the fact that there was equity funding. Secondly, there's an observation in 72 that the IFA and promoter fees, they were seen as effectively a fee for such equity investment. That's not actually what 285 of the Upper Tribunal says. That the right way of looking at this is that the IFA fees, they're a cost associated with raising the finance, and that submission is obviously right as a matter of fact. It doesn't actually perhaps make any difference to the analysis whether you label them as a fee or not. But what does matter in my submission is that they are undoubtedly expenditure, and they are related to the conversion. They raised funds that were used to pay for the conversion. So that was the second point. And then the third point that was made was to criticise the Upper Tribunal for saying that the revenues approach would operate to restrict and reduce the effectiveness of the regeneration of disadvantaged areas, which was the underlying rationale for the relief. I simply say that the Upper Tribunal was fully entitled to that observation. What it was doing, of course, was reflecting what it had said in 284 about the revenues restricted interpretation of in connection with. And of course it's right to say that on the revenues case, one method of raising finance is not going to qualify. The Upper Tribunal is perfectly entitled to take into account the fact that that restricts the scope of the relief. That's what fees would connect if the revenue were right. And the Upper Tribunal is equally entitled to observe that that may reduce the attractiveness of the relief, that may run counter to the ultimate legislative purpose of encouraging projects of this nature.
So if the equity finance were to have been raised by a company issuing shares, you would say that taking the advice of the merchant bank on the price that should be asked for the shares would be allowable.
Yes, I would. That's obviously not the situation that we're dealing with here.
No, I follow.
But there's nothing in the legislative scheme or context or purpose that permits one to say that there is a bright line and that a fee of the nature that your Lordship has just described to me is beyond that line and therefore not capable of qualifying. So in my submission, there's nothing in any of the criticisms in relation to the revenues primary case. I just want to deal with 2 points that were made towards the end of the oral submissions yesterday, and then that's it on the revenues primary case. The first is there seems to be a suggestion that there was something odd, I think that's how it was put, about the LLP paying for these fees. There's nothing in that factually. We saw the evidence of Mr. Smith that this was a cost that one would anticipate the developer would pay to be added into the price. But suppose Downing had paid. Equally, Downing would have taken account of fees it had to pay in setting the price. So the point about oddity, A, it's not odd, and B, it doesn't advance the analysis anyway.
Yes.
There was also, this is the second point, a criticism that the FTT had somehow failed to address the degree of connection required. That was an observation made yesterday. I don't accept that. You can see the FTT doing that very exercise of identifying how much of a connection it thought there needed to be in FTT.
Sorry, are you talking about the FTT?
Well, I think put in terms of the FTT, and it may have been the UT, it doesn't really matter because I simply say that FTT 147 to 155, you can see the FTT looking to illustrate where it thought the scope of the concept lay. It so happens that the Upper Tribunal found that the FTT had been over-generous to HMRC, particularly in paragraph 155 of its decision.
How does that square with your point that it's all a question of evaluation and that it's a question of fact for the fact-finding tribunal?
It marries up in this way. The bright line, where the FTT has been too generous, was in trying to draw a bright line of saying if it's to do with the establishment of the business, then that just can't qualify. That was the bright line that was possibly too generous to the revenue. So this is not. What I'm trying to say is it's not some sort of free for all that the fact-finding tribunal gets to say that it's in connection with because I say it is. There is a process of analysis. All that the Upper Tribunal was doing was saying that the FTT had possibly gone a little too far in its paragraph 155, but none of that infects the...
As a matter of law.
Yeah, well, that's what they say. And the reason it's a matter of law, just to pause on that point, the reason it's a matter of law, I suppose, is because of the nature of what the FTT had said in that paragraph is particular costs are not capable of qualifying. I think what you see the Upper Tribunal doing is a more nuanced exercise of actually investigating do they or do they not qualify. So that's the primary case. The revenue secondary case is on apportionment. We've dealt with that in writing in our response schedule, paragraphs 61 to 68. So far as the written arguments are concerned, the revenue took a two-step analysis. Recall there was a first step, £50,000 of the IFA fees, and being a site-finding payment, that's paragraph 77 of the revenue schedule. That point wasn't actually developed already. Not entirely clear whether it's still being, because it wasn't mentioned already. I simply say, as I've said in the skeleton, that wasn't the basis of the case below. That there wasn't a case made that positively that there was a site-finding payment.
I'm not sure that I know, perhaps there is a finding about this. Who found the site? Was it Downing? Was it OVL? I don't know. I don't mean, you may tell me there is a finding about who found the site, but there is. It's passed me by.
Mr. Levy of Cambridge, who corresponded with OVL, I think is the position as to whether there's a paragraph in the first-year decision that states that. Come back.
I think there may be. An approach to Cannock by Cambridge, if I recall correctly.
It's paragraph 48 of the FTT
Thank you.
decision.
I'm very grateful. It was Mr. Victor Levy.
Paragraph 48, did you say?
48 of the
FTT.
FTT. That deals with the finding of the site.
Well, on that finding, the IFAs had no part in finding the site.
Right. And that's the point we make in writing. Yeah. There's nothing there's nothing in the findings of fact. So quite apart from the point that this is quite a significant element of the revenues case, and to make that there's nothing in the findings that supports it. And we give references to what the FTT did find, which is FTT 114. That tells you what the IFA fees were paid for.
Sorry, FTT 194.
What 114?
114. Yes.
And we don't need to get into this. first step falls away. So it wasn't probably quite but to the extent it's still pursued, it's just wrong. The second step is what I might call the package point. So it said, well, money was raised. That was the purpose of incurring costs in relation to IFN promoter fees. So the money was raised. That money was an undivided fund, and it was spent on a package of items, some of which qualify for BPRA and some don't. Now, as it happens, the focus before the first tier, and I simply make this point to ask the court to bear it in mind when it's looking at the first tier, in particular, dealt with this. And actually, to a large extent, before the Upper Tribunal, the focus of the revenues case on apportionment was very much on the exception in relation to land. That was certainly how matters started in the first tier. It is true that the point was raised in the Upper Tribunal by reference to package, but again, certainly my recollection of the arguments, I didn't see anything in the transcripts you were shown yesterday that disturbed this, was that the focus again was very much on the exception for land in 360B sub 3. But what we have is the first tier tribunal rejecting the argument that the IFA fees were in part incurred on or in connection with the acquisition of land or of rights over land. That was FTT 201. And you can see that the funding that was
201.
It's 201, my lady, in the FTT. And that responded as part of the to the scope of the revenues case as it then stood. And they reached the same conclusion for the same reasons that they set out in 201 in relation to the promoted fees. You see that in the first sentence, 203 in the FTT 40349. Now, the Upper Tribunal, they held, and this is 289, that the first tier had been entitled to reach that conclusion. I've got a finding of fact that the IFN promoter fees, they were incurred for the general purpose of raising equity for the project, and that one couldn't on the facts, or not that one couldn't, in this particular case, it was not right on the facts to say that they were raised partly in connection, they're focusing on the acquisition of land, but exactly the same point would arise in relation to other non-qualifying items. And in my submission, the Upper Tribunal was fully entitled to deal with the revenues case on apportionment as it did in 288 and 289 of its decision. It recognised, I think if one looks at the transcript of the questions that were being put to me by Judge Scott, you can see where their observation that the revenues case has a superficial attraction in 287. You can see perhaps where that comes from. But they were absolutely right in my submission, in the conclusion that they reached, because simply saying what we are dealing with is a mixed fund does not, in my submission, establish a connection either with acquisition of land on the one hand, or if we look at other non-qualifying items, or the other. And if we stick with the land for the moment, we'll just test it in this way. We know that ultimately £15.5 million was raised, and we know that 7 million was borrowed from the Co-op Bank. If you're looking at the acquisition of freehold, 2.5 million, of course it's right, we do not know which pound notes, it will have to be Scottish, or pound coins, were used in order to pay the 2.5 million. But no one is saying that there was some segregation of equity finance from debt finance that were kept in different bank accounts to do a tracing exercise or anything like that. As it happens, we do know that the bank debt was secured on the property. So if you're thinking about this project, and you're focusing on the property for the moment, you may well be more what is the bank debt linked to the fact that it's secured for sale, it's linked to property. But none of that in my submission really matters. All of this is ultimately really a question of fact, sort of factual interrogation of the fact-finding tribunal. Malone Friend is trying to elevate this to a point of legal principle, to say as soon as there is a mixed fund, there must be some sort of apportionment. That's not in my submission how this legislation either is intended to work nor how it does work.
Yeah.
And the flaw really in the revenues case, it's quite well illustrated in my submission by Malone Friend's final fallback, because he's driven to say, or that he was careful to say orally, that his preferred analysis is for some form of apportionment. But he is still running the case where if I can't apportion, or if I don't have a principal basis for apportioning, then none of this expenditure qualifies. Now, I do say that is an extreme and an unjust result that would be a very surprising one, and one which is inconsistent both with the statutory scheme as a whole and indeed with the careful drawing of the exclusions in section 360, capital B sub 3. And having regard particularly to those exclusions, I say the Upper Tribunal was right in the construction that it adopted in 289 of needing to find some identifiable element of the expenditure that had been incurred in a relevant way with one or more of those exceptions. So that's what I propose to say about the revenues alternative case. That's it on topic 1 on IFM promoter fees. Topic 2 is franchise costs, which I'll go on to deal with now. That's the revenues ground 4. We deal with this in writing in our response, skeleton paragraph 69 and following. And your Lordship will recall we're dealing with the two payments. It's the $15,000 to Ramada and the £248,000 to Sang. Those two payments only.
And the $15,000 is, as I understand it, if you like, a trademark license. It's the right to use the brand name.
And we can see how the first tier saw this in FTT 209.
FTT
209, it's 4351. 208 starts dealing with the sums paid to Ramada. £15,000, that was live, but that was abandoned during the Upper Tribunal.
Yes.
The revenue abandoned its appeal in relation to £15,000 sterling. They were treated very compendiously in the argument, that's reflected in 209. The finding is that those payments ensure the property complied with the requirements and branding to enable its operations as a Ramada Encore hotel. And I make it.
Well, they're talking there about payments plural.
They're talking about both.
The second of which, the technical services one, would have been to ensure the property required with requirements, but the one that is now in issue is simply about branding.
Branding, which is there in 3 lines from
Indeed.
So they've dealt with that. There's no
Yeah, of course.
Run it together.
Yeah.
I'm so sorry. I'm very sorry. I didn't hear what you said.
No, they are dealing with both together, I agree with you.
The submission I make is very short indeed. The objective of this development was to convert the disused building into a Ramada Encore hotel. Clearly, the hotel can't be converted into a Ramada Encore hotel unless access to the Ramada brand is secured. What's more, experience tells that the particular brand of hotel that one is looking at has an impact actually on how it appears, signage in the vestibule, all those sorts of things. So it inevitably has an impact on the design appearance of the hotel premises. So the FTT is perfectly entitled in my submission to this conclusion, and equally the Upper Tribunal, in its paragraph 324, was entirely justified for Article 239. In noting the need to be able to use the relevant franchise and comply with the franchise obligations. Now, it's not an answer to that in my submission to say, well, you could have done this differently. You could have had a conversion project that got the building to a stage where you could then have gone out and started talking to different hoteliers about whether they might want to team up with you and agree that you could use their brand. The deal in this case is to produce a Ramada Encore hotel. And plainly in my submission, the expenditure to obtain the trademark license is in connection with that conversion, precisely because what is sought to be produced is a Ramada Encore hotel, not any old hotel.
And you presumably say that the fact that, I think it's the fact, that the trademark license was granted to the operating company rather than the LLP makes no difference.
Makes no difference at all, because that still affected the conversion that needed to be done. Exactly. Simply observe, going back to the legislation, this is a point that I touched on with Lord Justice Lewison yesterday. If we're looking at qualifying business premises, absolutely right, it is enough in order to constitute qualifying business premises that the qualifying building is available and suitable for letting for use as in a trade, etc. Is in the authorities page 12, but expressly actual use is also recognised. So Parliament has got two situations in mind. Either the building is actually being used in a particular way, or it is available and suitable for letting for use, and either will do. So it wouldn't be right to say, well, you could have got allowances if you'd done this conversion differently. Simply got the building up to the standard, as I say, that it could theoretically then have been possible to enter into discussions with the tenant. We look at the deal that was actually. So those are the points in relation to the franchise costs. This one footnote point, it was said orally that the franchise fee, that was a cost of operating the business, but for the reasons I've given, I don't accept. That's not
If you had got the building, you converted the building with Ramada's advice to whatever standard Ramada thought was appropriate. So it's now available for letting, and you want to let it. So you look for a hotel operator who's entitled to use the Ramada brand, and you find, yes, there is an operating company who's been granted a trademark license to use the Ramada brand. We will grant a lease to them, which I think is more or less what happened. Would you say that in those circumstances, the trademark license granted to the lessee was part of the cost of conversion?
Well, it may depend on precisely what the facts actually were. We're dealing with a case where the brand is being secured up front and at an early stage. That's the case we've actually got to deal with.
Right.
I think the case your Lordship puts to me might be a weaker case, but it doesn't undermine the analysis that I'm advancing here. The man friend observes to me that the brand affects the whole design of the property. And that ties into what I've just said about up front. You know where it is you're going to end up, which does, in my submission, differentiate this case from the example.
Yeah.
So that is Ramada. As to Sanguine, second payment for £248,000. I can do this without having to make you skip between the FTT and the Upper Tribunal. The Upper Tribunal, I think, sets out everything we need. It's 310 and following, so core 236. If you're looking at the first tier, you need two bits of it. You need the narrative of the facts at FTT 55.
Sorry, I missed that FTT.
I'm so sorry, my lady. Everything we need is from Upper Tribunal Para 310 and following, which is core 236. The paragraphs in the FTT that are being recited are FTT 55, which is the narrative of the facts. And then the FTT's discussion 206 and 207. And so what one sees is that there had been discussions between the developer and Sanguine, but then what happened was the developer OVN went ahead with a different counterparty, then Hospitality, and OVN agreed that it would pay Sanguine the £248,000. And you can see in UT 316, and this is clearly right on the facts, that payment essentially was the recognition of the loss of an active role for Sanguine in the future design and development of the project. Now, can I take this in two stages? And I say, first of all, the UT's analysis is absolutely correct. I need to deal with the point that was made yesterday about whether the UT had a basis to intervene. But if I just start with what the right answer is, first of all, the Upper Tribunal is entirely correct in my submission 317, where it says that inevitably there will be design and development stages if we're trying to establish that the business kind of building right, so that the business can be run. And equally, it's entirely right to say, well, in practice, there can be parties in the project chain that are replaced. That's the observation 317. The point of principle that I remark on, which in my submission is clearly right, is that there isn't any distinction between a payment on the one hand for work that is done under a contract that's to do with the conversion, and on the other, a payment to remove a contractual counterparty, either who's done work in the past and wants paid for it, or who's been removed from the project and denied the opportunity to do the work.
Sanguine, in fact, contributed nothing to the design of this.
No, that's right, they were paid off.
Yeah.
But that, in my submission, doesn't cause me any difficulty, because this is simply a cost that is incurred in the context of the conversion project.
But one cost, or one scenario, the cost is incurred to do the conversion works, and in the other it's incurred not to do the conversion works, to go away.
And, my lady, my point is that both...
Yeah, you say both are...
Both answer to the description of in connection with. The point your ladyship puts to me would have a great deal of force if we were looking at expenditure on conversion. Because the revenue would say with considerable force, well, you're being paid not to convert. That's not the legislative test.
No, but sorry, I was just at an earlier point, and it's a very basic point, but you simply can't say they're payments for the same thing, because they're payments for diametrically opposed things.
I'm not saying they're for the same thing. What I'm saying is that there is no difference in the context of this legislation between those two things.
Yeah.
But I'm not saying they're the same, just to be listening. So, in my submission, as a matter of what is the correct analysis, the Upper Tribunal's Already, a case was advanced to say, well, there was no basis to intervene. So I need to deal with that as well, because the analysis might be as good as it can be, but if it wasn't justified in setting aside the FTT decision, well, that may nonetheless a problem. There were three errors that justify intervention. The first is the finding that the first tier tribunal had looked at matters through the wrong end of the telescope. In fact, I used the language that I think cropped up a couple of times yesterday. So that is that is UT 95 to 97. And that does, in my submission, in effect, what comes later.
Yes.
I can see the scope for argument about exactly what has been set aside. But clearly in my submission, that justifies, if the exercise has been done wrong, and the UT has found that it's been done wrong, the UT in my submission is entitled to look at this payment for itself and form its own view. That's point one. The second point that would justify intervention is Upper Tribunal 157, which is the error in FTT 155 that I've already touched upon, about drawing the line in a place slightly too generous to the revenue.
Yes.
And the third is that even if I'm wrong about both of those, the FTT actually does go wrong in law in 207 of its decision. In the final sentence, because the FTT says in terms that payment to remove sanguine from any involvement in the project, they say it cannot be treated as qualifying expenditure. So on any view, that's an error of law, because it depends on the facts whether or not it qualifies. There isn't some principle that because you're removing a counterparty, it cannot qualify.
That's quite a narrow reading of the words that the FTT used. I mean, they might have meant does not on the facts. I mean, cannot. It's not necessarily. Because they start this clause of the sentence by acknowledging a wide construction of in connection with.
Well, but in a way, that rather makes my point.
Yeah.
Cannot. I can see there's room for debate. You could say, well, cannot, read in context, really meant
Does not.
does not. I say what they're saying, having just noted the width of the construction, that what they're saying is cannot in the sense that it's not capable.
Right.
I don't need that point, but because I get home, and because of the errors that have already been identified, UT 95 to 97 and UT 157, in any event. There was also, but I think this was just in writing, I was doing this very briefly, a suggestion that the sanguine payment was in connection with the possibility of ODL and sanguine working together. That's in the revenue skeleton. I simply say that seems to rewrite facts if one looks at FTT 55 and then 206, 207. And as I've submitted, what this bend is concerned with is sanguine's involvement in and removal from project. So in my submission, the Upper Tribunal was entitled to intervene, and it reached the right conclusion in relation to the sanguine payment. That's topic 2. Topic 3, I was just going to flag, I think I do no more than flag, a couple of points of detail on apportionment. That is the revenues ground 2. We've dealt with this in writing in our response skeleton, paragraphs 46 to 52. Now, from Mr. Gammy addressed you on the question of apportionment as a matter of principle yesterday. I'm not going to repeat that. I'm only going to flag these points that we just refer to where you see them in our skeleton because of the indication from the letter from Mr. Davey that really in this court all he's pursuing is the point of principle. Should there be an apportionment? Should there not be an apportionment?
Yes, I mean, he accepts it if there is to be an apportionment. We're not the people to do it.
No, indeed. And that's a development because there was an illustration of the apportionment the revenue wanted, which is Appendix 1 to the skeleton. And all I would do is flag the points on that.
Right, I think the point of the illustration was simply to say that the UT said, well, there's no means of doing it. And Mr. Davey says, well, there is a means of doing it. Here's one way. I don't think he's saying that.
On the one way, it does give rise to some serious problems, which we note in paragraph 52 in the skeleton.
Yeah.
Given the nature of the argument, I wasn't proposing to take up time addressing you on what those problems are. I thought we'd set them out in writing.
Right.
Those are the response points. So that takes me to my topic 4, which is to open the LLP's appeal on the interest amount, which is LLP round 2, which is my last topic. And this is
interest and license fee.
Correct.
Yeah.
Yes. And I'm afraid inevitably I will probably lapse into calling it one thing at some points and interest at some points and license fee on others. It's been referred to in both ways. This is dealt with in our appeal skeleton, paragraphs 55 to 64. The first tier, this was FTT 172 to 181, concluded that what we were dealing with here was a commercial arrangement and that the license fee payment did qualify for BPRA. I say that the FTT was entitled, indeed correct, to reach that conclusion. The Upper Tribunal was wrong to intervene. What I'm doing, of course, at this point in my submission is I'm assuming that this court is against the LLP and LLP ground 1, and so one does interrogate the license fee itself.
Can I just ask a question? What you say in your paragraph 56 of the skeleton, which is core bundle page 104, is under the development agreement, the developer agreed to pay $350,000 to the specified bank account. But isn't the payment, according to the intercreditor deed, being made by the LLP? Paragraph 33, page 33, supplementary 1, funding provisions. The syndicate shall pay the license fee amount into a deposit account to be drawn down in accordance with the terms of a license deposit. In clause 16.5.2d of the intercreditor deed, page 153, says that the balance of the subscriber's account, that is the LLP's account, not the co-op, shall be paid into the interest account. So isn't the payment coming from the LLP, not from the developer? I misunderstood that?
I think what we were trying to do is recite what was in the development agreement, but I can see I may not have quite.
Well, I'm looking at page 33, which is your cross-reference, Schedule 2, paragraph 2. Immediately on the date here of the syndicate, that's the LLP, shall pay the license fee amount into a deposit account to be drawn down in accordance with the terms of a license deposit deed. So the money comes from the LLP, goes into this interest account, and what happens to it is then governed by the documents relating to that account.
I see your point. I think the red line is developer substitute.
Well, can we also look at page 22, Schedule 1, paragraph 1.2, which may be the source of concern. Page 22, 1.2. The developer paying the licence fee amount.
Yes, developers to pay the licence fee from an account which has been funded by the LLP.
Well, it says on the date here, so I think there's an inconsistency.
Right.
It may be that the drafting isn't perfect and doesn't marry up perfectly. What is right is that it is true that this is money that forms part of the overall development sums. It's money that starts with the LLP. Money is placed in the account and then governed by the license deposit. That is the developer's money, which the developer then pays to the LLP for the license on the quarterly basis. That's
Well, why is it the developer's money? Except, I mean, the developer is paying the licence fee out of that account. That's true.
and it was the developer's bank.
Oh, is it?
I believe so. Yeah. Yes. I've been intending, but it sounds like perhaps I shouldn't do this, to take the document short. It may be that actually I should just walk you through the clauses as best I can. Because it is worth just having alongside each other the development agreement, the license deposit deed, in particular. And I think we've looked at the documents that we first of all need to have. So page 33 in the supplementary bundles, the clause we're looking at in relation to funding provisions. Paragraph 1 is payment of the development sum, and paragraph 2, the chair makes, which is quite right, it is the syndicate in that paragraph, statement of payment that ends up in the account governed by the license deposit deed.
And the licence deposit deed requires the developer to pay a sum equal to the interest on the loan. And if there's a shortfall, because the money runs out, then the shortfall is to be paid either by the developer or it's to come out of the cost overrun account. And the cost overrun account is also coming out of the subscriber's sum or subscriber's amount. So that also comes from the LLP. I mean, this goes to the question of risk which you talked about. So part of the risk of the hotel not being completed on time is borne by the cost overrun account, which I think is 350,000.
I can't remember the exact figure, but that may well be in the right ballpark.
And if it's still not built, then the developer stumps up the difference.
Correct.
Yeah.
And that license deposit deed, that is in the supplementary bundle, tab 5, page 171.
Yeah. And if the hotel is built well within time, then whatever's left goes back to the LLP. I know there was an argument about whether there was a mistake or not, but the UT said no, there's no mistake.
The UT said no, although in the events that happened, it was built early, and what was
Yes.
LLP.
Yeah, because clause 6 was ignored.
That's FTT 110.
Yeah.
Yeah. And your logic is quite right. There was debate for many as to whether that was a mistake or not. You can well see how a mistake might have been made, because you've got definitions of chargeor and chargee, so they were in the wrong place. The UT disagreed. We've noted, and there's a footnote in our skeleton, that if that really matters, we do say that the Upper Tribunal was wrong to have said it was a mistake. If you look at what actually happened, you look at the commercial sense of what's going on. If you're looking to incentivise the developer, it wouldn't really have made sense to say, well, the LLP gets anything that's left if the property is built early. None of that, however, really touches the main point that I'm making, which is that if we're looking at risk, the risk of the overruns is laid up on the developer. If I'm right about the stake, there's an additional incentive in the sense that the developer, if it's able to do this early, would be entitled to any balance that's in the bank account. I fully accept the Upper Tribunal said we're not prepared to correct that. As a matter of construction, our view is that clause 6 was ignored. That's what I said. I do say when you look at what actually happened, FTT 110 in the commercial reality, better analysis is that clause 6 is a mistake. But I don't need that point in order to get home on my ground too. Also, without wanting to sort of add to the complications of much drafting out who paid the money in, but just picking up on the point my name made, Mr. Falk made to me about the development agreement. If one looks within the licence deposit and clause 3.1 on page 172,
Yes.
you see it's recorded that the chargeor has deposited the licence fee.
That's the developer.
That is the developer. So that there's certainly there's not perfect consistency in these documents, if I can put it that way. Because I absolutely take the point that my Lord Justice Lewison makes in looking at the development agreement that says syndicate. This document suggests something slightly different. Nothing really turns on.
Right.
So just while we're on the licence deposit deed, so of course these points well in mind anyway. Clause 4, interest on the account released to chargeor, so that's the benefit of ODL. 5 deals with actually the licence fees being paid, and then 6, the point I've already touched on, payment. So, big picture, first of all, what did the licence fee do? It provided the LLP with the funds it needed to service the interest on the £7 million loan that it had taken from the co-op bank. And the evidence was that that was a normal approach in pre-funded development structures. And it also, as I've submitted, it laid off risk.
Why is it in the hands of the developer? Why doesn't AVL just keep the money?
I'm not disputing that they could have done a different arrangement. I'm looking at the arrangement that they actually did and what they actually achieved. So one could have done a different contractual arrangement, saying we the LLP will pay for the first X months. After X months, you the developer will pay. I understand that. That's not what they did. We're analysing what they actually did.
Yeah.
I suppose in relation to the point that your Lordship's just made to me, my point about clause 6 and whether actually the balance was available contractually or not, that might have some relevance to that, I suppose. Although equally with that, you could hypothesize a different arrangement again. We will keep this money. We, the LLP, will keep this money. you will pay it for the first X months. If you get the development done a month early, here's a formula that means that we will make you a payment. Economically, that would come to much the same thing. But that's not what we're testing.
No.
What is absolutely right is that bank borrowing has been taken, interest on the bank borrowing has to be serviced, the development project has to be carried out before the hotel can be opened. And so the LLP has to find a way, and there's a variety of ways in which this could be done, no doubt, but it has to find a way of funding that interest cost. Now, the evidence, and this was particularly Mr. Smith, which is in the supplementary bundle, volume 4, tab 83, page 939, which I think you could already have read. He said this was quite usual, certainly in arrangements that where tax incentives were at play. And there was also evidence on this, again, which I think the court would have read, Mr. Lewis, paragraph 116, supplementary bundle, page 504, and Mr. Tracy, supplementary bundle, page 623.
Page, the last one?
623.
Sorry?
It's supplementary bundle, page
623.
623. Mr. Tracy.
Yeah.
As for the practice in this area, the other background point with all of this, and where the particular approach that was chosen does fit in, is that it's important to bear in mind that the investors would be asked to invest at a fixed price. So if the project overruns, and so for example more interest is due to the bank, the last thing the LLP wants them to do is to go back to the investors to raise more funds. That's one of the reasons why they look to have risk sitting with the developer, and that again is in the extracts of the evidence from Mr. Lewis, Mr. Tracy that we've drawn to the court's attention. Just for completeness, that fear about overruns and disaster scenarios and the like, that's not a fanciful fear. If you look at Mr. Lewis's witness statement, paragraph 27 mentions supplementary bundle tab 35, page 549. That's the evidence about West Bar. That was the police station that was mentioned by Mr. Gammy in his submissions yesterday. West Bar didn't make it into the FTT decision, so there are no findings about it. But Mr. Lewis's evidence was that this was the development where they found asbestos, and that would cause serious overruns and So what does this arrangement do? Well, it gives the LLP a source of funds to meet the interest payments. Your says to me, well, it doesn't need it because it could have kept it. So that's not an answer. We look at what they actually did. And it transferred the risk of overruns to the developer. And so that does have the commercial effect of incentivising OBL to get the development done in a timely way and putting the financial consequences of delay onto OBL. So that's the commercial background to this. The other important background point is this. It cannot in my submission be said that the interest amount somehow wrongly inflates or ramps up the claim for business premises renovation allowances. As for two reasons. The first is we know from Mr. Douglas Smith's evidence that this license fee of this nature was a cost which, as a matter of market practice, was expected to be borne by the developer if there was to be an arrangement like this. This is how it was done. It's actually a scenario that's not...
But how does that... I don't understand. Just tell me how that helps.
How that helps?
Yes, we're talking about what Mr. Smith called tax-driven investments. So the idea of a tax-driven investment is to put in a claim for BPRA, which is as high as it can go.
That's not a fair way. If you look, one has to look at what he actually meant when he talked about tax-driven investments. He was talking about investments where there was a tax incentive.
Yeah.
He certainly wasn't saying the objective is to get the claim as high as possible.
Right.
He does actually I'll need a moment to find it, but he does actually have a definition of what he means by tax-driven But if one stands back from this, this item of expenditure, it's a cost that the developer's got to bear. And actually, it's no different really from any other cost that the developer has to bear. The developer knows it has that cost. And that's part of the exercise of converting the property. That's one way of looking at it from the developer's perspective. Perhaps actually not the correct way of looking at it. If we look more directly at the price, the evidence was, and I don't understand this ever to have been seriously disputed, the evidence was that the price of the development, so the overall sum that the investors were being asked to fund, that was based on what was called the stabilised Simmons valuation plus a premium. So it's what Mr. Lewis called a top-down approach. This is paragraph 85 of Mr. Lewis's witness statement, which is in the supplementary bundle, tab 35, which will be in volume 2, page 573. And it's stabilised valuation plus a premium of 15%. I don't need the numbered points on the paragraph 85, but the explanation of how they actually did price it is in paragraph 85 itself, but supplementary bundle 573. This ties into the point that a friend, Mr. Gammy, made yesterday, that the price is the price. Because the way they worked it out was you've got the valuation, it's appropriate to apply a premium to it. Price doesn't change whether there's a capital account, is the point I'm going through yesterday. I say, looking at this, the price wouldn't have changed whether or not there was a license fee. It's still 15.5 million. Is the appropriate figure. Now, the issue that the Upper Tribunal identified and the difficulty in the complaint that the Upper Tribunal made in relation to the license fee, you can see right at the start of their decision on this in 226, before on page 220. They seem to have seen this as money being passed backwards and forwards to no commercial purpose other than increasing claim for capital allowances. They describe it as a far clearer case of circularity and uncommerciality than capital. I've got submissions to make about that. But the headline points I make up front are that observation ignores the fact, first of all, that through the license fee arrangement, the LLP did lay off risk to the developer. That was a legitimate thing to do. And secondly, it ignores the fact that the price was fixed through the formula that I've just shown you from Mr. Lewis's evidence. Now, before I turn to the in connection with the test, just on self-cancelling, because that's where the Upper Tribunal begins at 226. And it's also essentially where it ends up. When you look, for example, at 254, and then 257, so having begun, I think it was at 226 with that observation, that's ultimately what they find. Self-cancelling in my submission is a finding that simply wasn't open to the Upper Tribunal. As we say at paragraph 61.2 in the skeleton, a conclusion that the license fee was self-cancelling, that can't stand with the acceptance that the license fee was expenditure incurred. You can't have those two conclusions sitting together. So that was a finding that wasn't open to the Upper Tribunal. Circularity is a slightly different point, which I'll address separately, but one simply cannot say, on the one hand, that the license fee is expenditure incurred, but on the other, that this was self-cancelling. It's also wrong analytically to describe it as self-cancelling. There was evidence before the first year, this is Mr. Lewis, paragraph 117, supplementary bundle tab 35, page 585, so within volume 2, that the licence fee had generated taxable income for investors. And that, of course, is perfectly obvious analysis. The licence fee was income from the LLP's property business, and that then is attributed to individual investors. So the notion of self-cancelling, other than as some pejorative description, is of no analytical value. So it's wrong. It's simply wrong, quite apart from not having been open to the FTT and as the UT in the light of the Crown's appeal case. So in my submission, for the reasons I've given, the first tier had been fully entitled to conclude that this was a commercial arrangement. The Upper Tribunal was not justified in upsetting that conclusion. Going on to the statutory test, but just before I do this, I'm very grateful to Mr. Gami. What I had in mind was paragraphs 4.2 and 4.3 of Mr. Smith's report. That's where he explains what he means by non-tax-driven and tax-driven investments.
Can you just give me the bundle reference?
Yes, of course. The supplementary bundle is...
So this is witness statement.
This is his expert report, yeah. It's page 862. I'm sorry, I'm going to find the tab in the volume. So supplementary bundle, volume 3, tab 57, page 862. And it's paragraphs 4.2 and 4.3.
Thank you.
It's where that one will find that as it's there. So I say, first of all, not open to the Upper Tribunal to upset the finding on commerciality. Actually, whether I'm right, whether I'm wrong about that, perhaps it doesn't really matter, because a sum of money was spent. We have to test, was it incurred on or in connection with the conversion, etc. Now, whether or not it's commercial, this is what they did. And I say, even looking at the use that OVL made of the £350,000, the money is still being spent, at least in connection with the conversion of the property. In my submission, one can look at it potentially in two ways, depending on how far one takes the analysis of the facts. One could look at the licence fee itself, and this is very much looking at it from OVL's perspective. The licence fee in my submission is a cost that's incurred by OVL in connection with the conversion of the property, because it's a fee that OVL had to pay to gain access to the land for the conversion to be carried out. My preferred approach, though, would be to look at the matter from the point of view of the LLP. And if one does that, one can see that what the LLP is getting is the interest cost being financed. So that if one's looking at what is the ultimate use of this money, the money is going to finance the interest, finance in the sense of pay for the interest that the LLP has to pay on the bank loan. And on that footing, it's no different in my submission from other finance costs incurred in connection with the conversion. Now, in the Upper Tribunal, there's criticism of my approach. They said, well, I rather hedge my bets. I'm not trying to hedge my bets. I'm simply acknowledging that there are potentially two objects of scrutiny depending on the perspective that you adopt. And the submission that I make to the Upper Tribunal and the submission that I renew in this court is whichever perspective one adopts, one gets to the same answer. Yeah.
If the LLP were paying the interest out of its own pocket to the bank, that would not be allowable, not least because expense. If the LLP said to the bank, well, would you commute the interest payments? Here's a lump sum. Would that qualify?
That's a good question.
Or commute the interest for 3 years or whatever it
Yeah.
is. I can't remember how long the licence amount lasted.
I myself wondering. I think you could have an interesting argument in the tax tribunal
Right.
if you paid up front, because I can see because
that's economically what the LLP got from this arrangement.
yeah, in a sense, I mean,
It's got an interest-free loan for as long as the licence fee lasts.
there is certainly debate if, for example, prepaying interest, could still be interest, but then you've still got to ask the question of enduring benefit and the like. So the question that Roger puts to me is possibly an interesting and a controversial.
All right.
It doesn't.
Perhaps I've set a hair running. I shouldn't have done.
But it doesn't. The question is also interesting from another point of view, which is that it does highlight, in my submission, actually the error that the Upper Tribunal fell into, which is to look at alternative ways in which this could have been done. That also feeds into what they say about tax neutralities, because we all know, and we're constantly told, and the revenue is told this, and taxpayers are told this as well. Well, if you've done something slightly different, it might be economically equivalent, but the tax effect is different. We have to tax what you've actually done. Now, the revenue may not like what has been done here, which is why we have all these adjectives being thrown around about artificiality, self-cancelling, circular, all the rest of it. But one has to remember that we're in a place where expenditure was incurred. This is all in the context of the money was spent. There was clear evidence as to the commercial practice for these transactions. And there is, in my submission, the necessary link with the conversion. There's also nothing odd or distortive about the result. In this case, there was mention of a passage in Lord Helsham's speech in Benedico, the need to take care about distortions and the like. But that submission, that ignores the very different statutory context in Benedico. One can absolutely see the concern about abuse if one's dealing with a rule giving allowances for expenditure on the provision of, in that case, the oil. But we are dealing with a situation here where the net has been more widely cast. So that's what I say about the statutory test generally. The other point that exercised the Upper Tribunal was on tax neutrality, which we deal with in paragraph 62 of our skeleton. And that was the point that the first tier had observed, and again this is all slightly in my submission doing the wrong exercise, because it's looking at alternative arrangements that could have been made. The first tier observes that the net amount of deductions for the LLP wasn't increased, because it said, well, if it paid this directly, you wouldn't have had the income, you'd still have had the finance cost of the bank. That responded to the revenues case as at that point it was being developed. In the Upper Tribunal, the revenue shifted focus to the position of the investors. And they said the problem with tax neutrality here is that if the LLP had paid this directly, it would have been a revenue expense, subject in square brackets to my Lord Justice Lewison's point about upfront payment, I suppose. And it wouldn't have been eligible for BPRA. So that's what's offensive here. The Upper Tribunal observes at 260 they're difficult because they found it unclear what impact point about tax neutrality would have for the first tier. one just needs to have what it's Upper Tribunal 260, and then that's referring to FTT 179, where they sort of bolt on their observation about tax neutrality onto the finding there's no commerciality. Taking it in state, the FTT was absolutely right in its observation at 179 to say that there was no increase in deductions for the LLP because the income it got from the licence fee was taxable, so there was a balancing act. What the Upper Tribunal responding to the revenue's more developed case was to say, no, we want to look at the BPRA provision. So the BPRA position. But again, that is testing the wrong thing. That's testing an arrangement into which they could have entered but didn't enter. Now, as it happened, the only real point of difference actually is one of timing. Because suppose over time the LLP had paid the interest, it would have had expenses. We know because the FTT found this to be the case in FTT 127. We know that it tells profitable in later years. So actually, never mind whether sideways loss relief was available. I fully accept they wouldn't have got deductions in year one. But had they done it another way, there would have been increased deductions in later years. All of this is just illustrating the general point I made. That if they'd done something else, there'd have been a slightly different tax result.
Yeah, no, your point is that we've got to look at the actual arrangement and not possible alternative arrangements.
So those are the first 2 points: commerciality, artificiality, self-cancelling. I should say just a word about secular, I suppose, because I would accept that that's not necessarily covered by a finding that the licence fee is incurred. But on secular, we know, because Tarrant Cashback tells us, and it's illustrated by EMDF and Mawson, secularity is not an answer, certainly not of itself.
It's relevant but not determinative.
Correct. And when one looks at the circumstances of this arrangement, it doesn't undermine the conclusion that the expenditure was incurred in connection with the conversion. So the third and final topic that I need to deal with is the exception for the acquisition of land in section 360B, sub 3, sub A.
Yeah. And your point is it's the person to whom the allowance is made who's got to do the acquiring, not somebody else.
And I've said
And that is a fairly straightforward point.
I've said it out in writing in paragraph 63.
Yeah.
It's the long and the short of it. The reason we say it is because you have to look at the scheme of the legislation and the focus on whose expenditure we're talking about.
Well, the person claiming the allowance is the person whose expenditure you look at.
Exactly.
And you disallow part of that expenditure if part of that expenditure has been incurred on the acquisition of an interest in land. And in context, that must mean the acquisition by the person who is claiming to have spent the money.
Your Lordship has a point. And it makes no sense in my submission to look at an acquisition by a third party.
Yep.
It's a very short point. And I probably can't really elaborate more on what we've said in writing, which is clearly made its way through to your Lordship. Would your Lordship just give me one moment?
Yes, of course.
Unless I can assist further, those are my submissions.
Right, so just looking at the timetable, that takes us to lunchtime day 4. Is that right?
I suspect it may well be, yes.
All right, so we're now looking at HMRC's reply. Well, we're just going to rise for a couple of minutes and take stock.
What I would just do while your Lordship is doing that is hand out those copies of the detail
Benedica at first instance. Yeah.
And before I forget, could I have the day 2 transcripts by email? They haven't reached me yet. I don't know if they've been submitted. Thank you so much.
All right, don't go away. We won't be long.
All right. All right.
Mr. Davey, we need not trouble you on the LLP's ground 1.
I'm grateful, my lord.
Sorry if that shot your fox.
Well, I might have gone to bed slightly earlier had I known. I'm very grateful for that indication. As ever, I'm in the court's hands. Had that not been the indication, then what would have happened is that I would have made submissions on ground 1, and then, well, if the court was so minded, I would have asked if I could make submissions in response to the licence fee point a little bit later, having taken stock of the submissions I've just heard. In other words, we deal with replies on...
You take your own order. I don't think it matters which order you want to take the points in. We would like to hear you on all the other points, or hear your team on all the other points.
Okay, I'm grateful for that, my lord. I think in that event, what I'll do is, I've got 1 point on the residue, which was a matter I dealt with in opening and Mr. Gammy dealt with. After that, I'll then hand over to learned friend Mr. Brinsby in Stockham to deal with capital account, Mr. Macklem to deal with his items, and then I'll come back and deal with the licence fee.
Right.
I've only got 1 point on the residue, and it is this, or to set the scene fractionally. In the course of learned friend's submissions yesterday, he did recognise the validity of the principle of undertaking an apportionment when you have a mixed payment of qualifying and non-qualifying items. That was day 2, page 142, line 20.
Yes, I remember asking about that.
My Lady Justice Falk then asked Mr. Gammy whether it was his case that none of the residual amount was attributable to the land. And learned friend replied in the affirmative. He said that the quotes, the rest of the claim is actually entirely free of that aspect of non-qualifying expenditure. What he'd said is he'd acknowledged the £34,999 of legal expenses, but beyond that, I understood him to be saying that nothing else was within the developer fee or developer profit or residual sum. That was page 143, lines 6 to 18. And the point I wish to make is that that submission, which certainly in oral submissions was asserted rather than supported, is unmoored from the evidential backdrop which I set out on the first day. I gave the references then, but briefly items that I referred to included Supplemental Bundle 4, tab 94, 1023. Responding to Supplemental Bundle, Additional Bundle, tab 5, page 74. And then there was the document that my Lord Justice Lewison asked be updated with up-to-date references, because it included bundle references from the Upper Tribunal. That was handed in on morning of day 2.
Yes.
Supplemental Bundle, tab 93, page 1014. That was certainly the original reference. And, of course, items we've cited in our skeleton argument. There was also, of course, the FTT's decision itself, paragraph 230, 1 to 4, where they found at 233 that, quotes, the profit paid to Cannock was attributable to all elements of the package, including the freehold premises. That's what they found at 233, by 230, little 3. And I should also say, to pick up on a point that was put to me on day 1, that the profit is attributable to all of the elements, including the freehold premises, is not dependent on there being a contractual obligation assumed by the developer to buy the land. Because, of course, the developer, as I intended to say on Monday, I think I said, but I say again, had already put together the whole package, including the land. They brought it to the LLP, which, as the learned friend Mr. Gammy said, was Cannock's, OVL's funding vehicle. So the proposition that the fee, the profit, is attributable to all elements, including the freehold, is not dependent upon us saying, here is a contractual obligation on the part of the developer to go and buy the land. So where does that leave us? I said I had one point. I think this probably was a long prelude to the point. In short, I do say that there's no basis for the point that was made that what we've got here is a sum of money which is entirely free from any non-qualifying component. And if you're in that world where the fee or the profit is attributable to more than one thing, one qualifying and one non-qualifying, then the parties, as I understand it, are in agreement that, in principle, apportionment is a valid thing to do. That appears to be common ground in light of the learned friends' oral submissions. You, of course, have my submission that we are in that world, and perhaps a point which may have gone slightly under the radar now, but I would say that whatever this court decides, unless it were to decide in favour of the LLP on ground 1, which I infer, unless the court were to decide that, then I say we are already in that world, because the Upper Tribunal found that an item of unallowable expenditure was legal fees. So it's not something we've looked at, but that was approximately £150,000, i.e. in addition to the £34,999. That's dealt with in the Upper Tribunal's decision at 291 to 307, with the conclusion at 307. They found that that component did not qualify. In that regard, they were upholding the FTT's decision. The LLP applied for permission to appeal the UT's decision. That permission was refused. So that isn't part of this appeal. So if we're in a world where the LLP don't get home on ground one, I say that necessarily we are in a world where it has been found that the development sum includes at least one non-qualified item. And if we are in that world, then it is common ground, it would appear, that apportionment is a valid and appropriate thing to do. That's the only point I wanted to come back on, residue.
Thank you.
Yeah, sure. Sorry, I'll just rearrange. My Lord, I'm replying, as my learned leader indicated, on the capital amount, as you would perhaps expect.
Capital amount. Yeah.
Indeed, my Lord, yes. I'll endeavour to address my learned friend's oral submissions thematically, so hopefully that will group them together rather necessarily than the temporal sequence that they were made in. My learned friend's oral submissions are in the transcript, day 2, page 117, line 16, to page 138, line 19. And I really want to make 4 points in reply. First, the approach that is to be taken in respect of the capital amount. Second, the commerciality of the capital account mechanism. Third, the point about beneficial entitlement to the capital amount. And then fourth, what my learned friend came on to last, which was HMRC's main argument. And there I need sort of sub-issues to address contractual arguments and then restitutionary arguments. So turning first to the approach taken in respect of the capital account, 3 points, or 3 sub-points there. First, the question of when do you determine if expenditure qualifies for BPRA? Now, just to be absolutely clear, HMRC's position without any equivocation is that you judge it on the day that it's incurred. I'm conscious that I may have caused some confusion for my learned friend. I didn't intend to. It's judged on the day it's incurred, and that is the point at which you determine whether it was incurred on or in connection with the conversion. So that's 25th of March 2011. My learned friend, under questioning from my Lord, did ultimately accept that that was also his position. For your note, that's page 119, line 22, to page 120, line 4 of the transcript. That's not surprising because it was common ground before the Upper Tribunal. So that was the position. The Upper Tribunal records it, as I set out in submissions, at paragraph 67(6) of the Upper Tribunal decision.
So if your bank loan includes an amount for contingencies, which may or may not be spent, whether you discover asbestos or whatever it is, you say that doesn't qualify because on day one you can't tell whether it's going to be spent or not.
Well, my Lord, it would turn on what that contingency fund is doing. So, and you'd need to look at the details of the contingency fund. But to the extent, well, one would have to look at it, as Tower indicates, in light of all the facts and circumstances. We would need to see if it involved circular payments, what was the access to that fund. For example, if the fund was fully available to the developer on day one to use, if it needed it, in respect of contingencies, then clearly you'd be looking at a very different circumstance to this case.
Well, leave the developer out of it. I arrange a facility with the bank for £7 million, and the works of conversion are going to cost £5 million. So I draw down £5 million, pay up front to the contractor, and there's a cushion of £2 million in case, for whatever reason, more money is needed. You say that £2 million doesn't qualify.
So what
you don't wait and see whether it's been spent.
Well, if I might ask, what's happening to the £2 million in this scenario? Is the borrower holding on to it until the contingency arises?
In the scenario I'm putting to you, the bank still has it, but it's available to the borrower to draw down.
Well, in that scenario, my Lord, no, certainly it wouldn't qualify because it wouldn't have been incurred.
Yes.
If the LLP had said up front, we have an unqualified obligation to pay you £2 million in the future, that would be incurring, and there one would look at what it had been incurred on, but in principle that would be incurred on day one, and one would look at it. And my Lord, just for your note, it's section 5 of the Capital Allowances Act. We haven't looked at it, but that's the provision that provides, as soon as you have an unqualified obligation to make the payment, broadly, there are some exceptions, but that's when the expenditure is incurred. The second point, my Lord, was a submission my learned friend made as to a requirement for absolute certainty.
My learned friend sought to characterise my submissions as saying that in order to qualify for BPRA, you would need to be able to say with, quote, absolute certainty on day one that the benefit of the capital amount would pass to OVL. Now, my submission, that rather falls into the category of straw men and bootstraps that my learned leader identified on day one. It's simply not something that I ever said. It's certainly possible to envisage a transaction where there's perhaps a very, very small marginal risk that the money might not go here to the developer, or that the funds didn't end up with the relevant counterparty. And in that case, we may need to have a debate about epistemological certainty and those kinds of questions. But that, in my submission, is simply not this case. As we've seen, there were three methods of withdrawing funds from the capital account. One of the three on HMRC's construction would lead to OVL never obtaining the benefit of the capital amount. And in order for that eventuality to arise, what was required was an event of default, which, as we've seen, was widely defined. So in my submission, in this case, there is clearly, and was clearly on day one, a substantial material risk that withdrawal would be made by the co-op under 3.5.3. My submission on in those circumstances, i.e. on the facts of this case, it cannot possibly be said on day one that the capital amount was incurred on or in connection with the development. And ultimately, that's what the LLP has to demonstrate. It's about the LLP proving that the expenditure qualifies for relief. And you have my submissions on that point. Just related to that, I'd submit it cannot be right that the fact that funds may ultimately inure to the benefit of OVL is sufficient for relief. Because if that were right, such a construction would be very easily open to abuse. One could simply take a very similar mechanism as we have in the capital account, but subject to a very small possibility that the money would go to OVL. So a bonus if you deliver the development 9 months early. Extremely unlikely to happen. But if it was said that it's enough that it may go to the developer, then presumably in that scenario the developer would say, okay, well, it's been incurred on or in connection with the development.
Yes.
In my submission, that cannot have been Parliament's intention. Third point to make on the approach is the significance of the analysis in contract and restitution. Now, my learned friend plainly does not accept HMRC's analysis of the position as a matter of the general law, so contract and restitution. In other words, that withdrawal under 3.5.3 would lead to OVL getting no benefit. It doesn't accept that as a legal proposition. However, as I read the transcript, my learned friend did not dispute that if HMRC's analysis of the underlying general law position is right, didn't seem to dispute that it then follows that the capital amount does not qualify for BPRA. So in my submission, it appears to be undisputed that if HMRC makes out its main argument as a matter of the general law, then BPRA is not available in respect of the capital amount. So that's the first point of approach. My learned friend then addressed what I termed the ancillary arguments, and two of them in particular. So I'll come on to address those before the main argument. So the first of his points, and the second of my points, was the commerciality of the capital account mechanism. Now, my learned friend was and always has been in these proceedings very keen to assert that these arrangements here involve the sale of the property to the market, £15.5 million. It's all commercial. It's all at a market value. It's just like, my learned friend says, just like Benedetto, perfectly analogous to Benedetto, buying an oil rig in the market. And it must therefore be the case, well, surely the capital account mechanism is a commercial thing as well then. And that ultimately is my learned friend's basis for challenging the commerciality of HMRC's construction of clause 3.5.3. Because the way he framed it was to say, well, why on earth would OVL give a rebate of £2 million to the LLP? There's 2 points to make in reply to that. The first is quite simply, and it's a point my learned leader addressed in opening under the heading of our Ground 5. This is not a commercial arm's length deal. The notion that this is an arm's length transaction akin to that in Benedetto is, in my submission, completely baseless. And my learned friend, Mr. Gammy, did set out his submissions quite rightly on the basis that this was a project put together by Cannock OVL, all as a package, cradle to grave. And as he put it, equity funding was, quote, the final link in the chain. It's page 79 of day 2 transcript, lines 2 to 22, where my learned friend makes those submissions. So as we have said throughout, the LLP was in effect CANOC or OVL's entity for raising equity finance. And the notion that those two entities are acting between one another at arm's length, in my submission, is simply not grounded in the real world. This is the funding vehicle of the developer. They're not independent parties operating in the market.
It's arm's length as between
Well, the investors.
the investors.
That's
and
the point I need to come on to.
Right.
So what my learned friend says is, well, it's a £15.5 million price that was sold into the market. Now, that is a market that is a market price may be true in one limited sense. And that limited sense is that there were high net worth investors who were prepared to pay that total amount for the Blush House development. But, and this is a point that can get lost in the mass of numbers and facts about this case, that figure of £15.5 million is not supported in any way as an actual market value for the hotel, the resulting hotel that was produced. Now, you've seen and been taken to, my own friends rely on the Edward Simmons valuations. The range of valuations go from £8 million as a bricks and mortar valuation up to 13.4 million, but that's on a stabilised trading basis after 3 years, factoring in trading potential. Now, I don't dispute the validity of valuing things in that way, but that's the range of valuations, 8 to 13.4. And the only reason in my submission there were investors prepared to pay more than £2 million above the top estimate for the value of the hotel is due to what was marketed as an apparent claim for BPRA and the sideways loss relief available to them to shelter their tax liabilities. Now, you have my learned leader's submissions in opening, but the more relevant value for the purpose of actually analysing the BPRA position to take as a sort of anchor or a grounding point is the figure in the design and build contract. Our submission in that regard is that BPRA is a relief concerned with the process of conversion, repair, conversion, renovation or repair. It's not about the acquisition of an asset. It's not about buying the end hotel here. It's about the process of conversion. And so the figure in the design build contract is at least the starting point for the cost of that conversion process. Obviously, we accept that the relief does go wider than that, but in terms of where you should be starting, my submission, the point to start, as my learned leader submitted, is you start at the 5.8 million figure in the design build contract. You don't start at the 15.5. You say, well...
So your point in a nutshell here, I think, is that BPRA is concerned with the costs of conversion, not with the value of the building once it's been converted.
Indeed, my lord. That's the first point that I make. I then go on to say that it's important. So that was really a submission that my learned leader made about the relevant figures. But when we turn
you say that the only reason the investors were prepared to pay more than the top Edward Simmons valuation was because of BPRA. That sounds to me like a finding of fact. Can we make it, or has somebody else made it?
My lord, in my submission, the notion that someone would be prepared to pay £2 million more than the top estimate of a project, there can be no rational, I put it this way, there can be no rational commercial explanation for that. Now, if you find an error of law in effect anyway, you're able to make findings of fact.
Yes.
My submission, the only thing that can be attributed to is the BPRA. And if one looks at the information memorandum or any of the documents associated with marketing this, it is blindingly obvious that this is a structure designed to generate tax relief. There's simply no question about that.
Yes.
But so that's the first point, that it's that lower figure of 5.8 million that's the relevant starting point for the BPRA analysis. But when we come to the commerciality of the capital amount, I also say it's important to bear in mind that despite my learned friend's repeated submissions to the effect, this is not a simple sale in the market of an asset or services at a market price in any real sense. There is artificiality baked into the arrangements with a view to maximising the BPRA claim, so as to make the investment attractive to high net worth investors. Now, the FTT found that in respect of the capital amount, the UT found it in respect of the interest amount. They both said there's artificiality here. In my submission, both of those things are artificial for reasons that I will address and my friend will address. But one can't simply say that this is just like Benedetto, which is what my learned friend sought to do. The only way in which you could draw a factual analogy between this and Benedetto is if, in that case, the Clyde Shipbuilding Limited Company, which was the supplier of the oil rig, had set up an LLP to raise funding to buy one of its own oil rigs, and then arranged for the LLP to pay significantly more than the highest estimate of the oil rig by reference to the profits it could generate in the trade in order to generate substantial tax reliefs. There is simply no analogy to be drawn between the two cases. And just while we're on that point, my own friend, in respect of the capital account, made the submission that he said that the fact that it's marketed to high net worth individuals, I say, is neither here nor there, even though my learned friends like to point it out that this was high net worth individuals getting some great deal to save them tax. That is precisely what the incentive was designed to do. Well, in my submission, that is a gross mischaracterization of the purpose of this relief. The purpose of the relief is self-evidently to improve the infrastructure of buildings in disadvantaged areas. It's, in some senses, quite telling that that's the view that the LLP takes of the relief. It is not precisely designed to derive tax benefits for high net worth investors. Yes, you have to have income in order to be able to take advantage of the relief. I don't dispute that. But to view the relief as being precisely designed to generate tax relief for high net worth investors, in my submission, is just plainly wrong. So just to end that point, I would submit that if there is any valid challenges to commerciality, it's to the substance of these arrangements, these transactions. It's not as to HMRC's construction of them. And if, when you're approaching the contractual documents and looking to construe them, you find yourself having a sense of unreality as to what is quite going on. Why is there a license fee being paid only to come back? Again, my submission, that's not attributable to HMRC's construction of the agreements, say the capital account deed in respect to the capital amount. It's due to the fact that artificiality is just baked in to the structure. It's a feature, not a bug. That was the first point on commerciality. The second was just to make the point that HMRC's construction, it's a point I made in opening, but of 3.5 of the capital account deed is not, in my submission, uncommercial. And this is what my learned friend termed the £2 million rebate. So just 2 points to make in respect to that. The first is that submission in my submission simply repeats the error of proceeding on the assumption that this was OVL's money on day one. And you have my submissions on that in opening. That was an error the Upper Tribunal made as well. But second, as to the point that my learned friend made as to why would OVL forego the £2 million sum of the capital amount under a 3.5.3 withdrawal, that argument obviously focuses on the relationship between OVL and the LLP. Why is it giving back the 2 million? Well, let's for a moment assume that the arrangements between OVL and LLP were at arm's length. So let's just take on board fully the picture that my learned friend seeks to paint. So we have OVL as a property developer that's put together this project. We have the LLP as an entirely independent arm's length investor. Now, it appears to be common ground, and the Upper Tribunal also held, that the scenario envisaged by clause 3.5.3 of the capital account deed is one where the project is failing. So on HMRC's view of the world, a clause 3.5.3 withdrawal would involve the developer of a failing development not getting or not receiving part of the total fee that it had initially agreed up front. I submit that that seems a perfectly commercial arrangement. You do the development, you don't do it very well, you don't get all the money that you might possibly have made under the development. In contrast, on the LLP's view, in principle, the developer, OVL, receives the same fee from the LLP for the development regardless of how the project goes. Raging success, abject failure, it gets paid the same amount no matter what. In my submission, that seems a far less commercial arrangement than what is actually arrived at on HMRC's construction.
So, in effect, you're saying that the capital account deed is a bit like a success fee. If it goes well, you get money. If it doesn't, you don't.
Absolutely. And if it's in the middle, you get a contractual entitlement under 3.5.4. Yes, madam. Turning to the third of my points, the beneficial entitlement to the capital amount, my learned friend addressed that point briefly. He made one point about interest accruing on the account, but I addressed that in opening. My lord asked me a question about that. And I said, well, the position in respect to the interest is the same as the principal. You can't do anything with it. No beneficial entitlement. The only other point that my learned friend made was to say, and this is, it's day 2 transcript, pages 127 to 128. Quote, HMRC's analysis can't possibly be right because on a multitude of other situations, even assuming that the revenue's construction of the capital account deed is correct, there were a multitude of situations where Cannock would have got the money. Now, in my submission, that's not the correct way to analyse the position in terms of beneficial entitlement. So to the extent we're using that tool as the FTT did, you already have my submission. You have to judge it on day 1. You have to judge the position on the 25th of March 2011. And on that date, it's clear that OVL was unable to withdraw the money directly for at least 3 years. Couldn't withdraw anything under 3.5.1 for 3 years. Was not able to deal with or use the fruits of the money itself or the fruits of the money in any way. And on my submission as to the contracts, that money was liable to be withdrawn by the co-op at any moment if there was an event of default. So in my submission, there was absolutely no beneficial substance to OVL's entitlement to the capital amount at that time. Now, it may be that OVL would obtain a beneficial entitlement to the money further down the road. So you could have an example. It seems what happened, well, we've seen what happened subsequently was that there was a withdrawal by the co-op and the OVL loan was commensurately increased. Well, at that point, OVL would have a beneficial contractual entitlement to the money. But because it is able to recover the money at that stage. But until that point, the money is basically in a blocked account. There's absolutely nothing that OVL can do with the funds.
And there's that point about the timing of when OVL becomes entitled beneficially, whatever that means, to the money. That is that irrespective of whether there is an implied term of a guarantee arrangement and or a restitutionary remedy, or...
Well, I'm certainly going to have to come on to address the restitution.
No, I follow, but I'm just asking, for the purposes of this point, the timing point,
yep.
Does it matter whether there is or there isn't a restitutionary remedy or the right of a guarantor to indemnity from the principal debtor?
In my submission, it wouldn't make a difference, no, because as on day 1 when the money is paid, there is no claim in restitution, there is no ability under the contracts to access the money. It would obviously change the analysis to some extent. It would be a more difficult case. I would accept that. But in my submission, no, there would still be no beneficial entitlement to the money. Just on that point, I would, as I did in opening, simply commend the analysis in BPRA Insurance, which is at tab 42 of the authorities to the court, and reaffirm that the FTT was perfectly entitled to use that tool when it was analysing the facts realistically. So, turning then to the main event, and I hope I can be finished by a short adjournment, my lord. I hope. Turning first to the contractual points, there are 3 points about the construction of the contract that my learned friend made that I need to address. The first is just to note that my learned friend on a number of occasions still seeks to rely on the information memorandum to construe the effect of clause 3.5.3. So the clearest example is day 2 transcript, page 138, lines 3 to 10. There was no attempt to engage with the authority, the Court of Appeal authority in Merthyr that I took the court to. But my learned friend just said, why on earth wouldn't you take the information memorandum as an indication of exactly what the parties agreed? Well, the answer to that is the answer I gave in opening. First, it's directly contrary to the binding Court of Appeal authority. And the second is that on the facts, it doesn't show what the parties agreed. And just to make that second point good, if we could go to the supplementary bundle tab 19. So it's volume 2, tab 19, which is the information memorandum. This is the section in the information memorandum dealing with the loan facilities.
Which page?
Page 382, my lord.
382, yeah.
Second, so you can see that the purchase of the property with finance through a combination of funds provided by members and loan facilities, including a loan facility from a major clearing bank. Limited recourse loan facilities have been agreed in principle, subject to documentation. So at the time the information memorandum is being drafted, they don't have the agreements. So you can't possibly say that they are describing the agreement that has been arrived at with the co-op, which is the as yet unnamed bank, that the loan arrangements are actually put in.
Can you help me where that is? I haven't managed to find that.
Sorry, my lady. It's the second, so page 382, second paragraph. Limited recourse loan facilities have been agreed in principle.
Yep, thank you.
It says to provide the fund with fixed term loans of approximately 8.3 million. Well, again, we know that the ultimate loan was 7 million.
Well, I think that
That might include it may include the OVL thing. Yeah, indeed, my lady. But on any view, the bank is not named and it's expressly stated to be subject to documentation. So it cannot be said to record what's been agreed. Can perhaps be said to record what OVL wanted the position to be, but that's neither here nor there, as we know from the decision of the Court of Appeal in Minerva. So that's the first point. Second point that my learned friend made was to say, well, if you're looking to see what's agreed between OVL and the LLP, you look at the developer loan agreement. I don't propose to go back to the developer loan agreement, but we've spent enough time on that. But that's page 136 of yesterday, day 2's transcript, lines 19 to 22. My submission, that's simply not right. The capital account deed is the agreement between all the parties with an interest in the capital amount, including OVL and the LLP. And you have all of the submissions I made in opening in respect of the correct construction of the capital account and how the developer loan agreement is subject to that contract. The third and final point on the contracts that my learned friend made was just to say that the capital account deed is silent on what happens in respect of a withdrawal under 3.5.3. Again, that is true in one sense. There are no specific words in clause 3.5.3. But in my submission, that is not to tell the whole story. The point, as you have from my opening submissions, is that specific provision is made by all the parties as to what will happen in a clause 3.5.4 situation. And that is the whole point of the maxim that I relied on, the expressio unius est exclusio alterius. It's just a normal approach to objective interpretation, objective understanding of what's been said, that if the parties expressly provide for a payment in one circumstance, A, and they make no provision in another circumstance, B, but no provision for payment in another circumstance, B, then they objectively intend that no such payment is to be made in circumstance B. To take a very simple and perhaps too homely example, if I gather my daughter and my son around the kitchen table and say to them in very solemn tones, I have decided to pay you, my daughter, £5, leave it there, it's very, very clear that I am not paying my son anything. And obviously that would cause a huge amount of trouble at home, but hopefully it illustrates the point that objectively what has been agreed, well, there said or agreed, has to be informed not just by the silence in the one clause. The relevant thing is what is said in the other clause. Yeah. So my submission, the objective intention of the parties is clear, that in contrast to 3.5.4, withdrawals under 3.5.3 did not lead to any addition to the developer loan or any other entitlement on the part of OVL. And actually, as far as the contracts are concerned, my lord, I think, again reading the transcripts, that in any event my learned friend's submissions on the contracts actually fall away because, my lord, you clearly characterised what my learned friend's argument was, and my learned friend accepted that. That's at page 135, line 11 to 136, line 10, and the summary that my lord set out was that OVL is discharging a debt obligation of a primary debtor, the LLP, it gets a claim against the LLP in an equal amount, you have my submission, that is a freestanding claim in restitution. It's not a claim under the contract. So I need to come on and address the restitutionary position. There are 6 quick points to make. It sounds like a lot, but I'm sure I can get through them very quickly. The first 2 are points that I did make in opening, but I do need to reiterate them because they are important building blocks in a sense. If it's right that that is what the LLP's case is, that this is all about a claim that arises in restitution as the result of the discharge of a primary obligation by a secondary party, then the Upper Tribunal decision is plainly wrong in law. That has to be set aside, which in a sense, as I said, is the first hurdle I have to cross. The second point I make, and I did make it in opening, if that is the case, in my submission, that is a deep...
Sorry, if what is the case?
If
that is wrong, or if that's a restitutionary claim?
If that's the case that's being put against me, and if the Upper Tribunal is wrong, well, first of all, if that's the case that's being put against me and it's the only case that's left, the Upper Tribunal is wrong, and secondly, it's a deeply unsatisfactory situation because it's a point and an argument that was not run before the first tier tribunal. It wasn't in the grounds of appeal to the Upper Tribunal. It was raised for the first time in the skeleton arguments to the Upper Tribunal, not addressed in any depth before the Upper Tribunal, and warranted only one sub-paragraph in my learned friend's skeleton argument. So you would be determining a question of restitution which may well have wider consequences without this point having really had any consideration below. The third point to pick up, my lord, is there have been some suggestions. My lord and I touched on it in opening, and my learned friend relied on it at day 2, page 130, line 5, that this is possibly a case of subrogation. And just to sort of clear away that thicket, it's not a claim of subrogation. The reason it's not is because the withdrawal by the co-op would discharge the co-op loan to the extent of the withdrawal by way of set-off. So insofar as money had been withdrawn, there'd be no subsisting underlying obligation to which OVL could be subrogated.
I don't think that matters.
Well
you can be subrogated to liabilities which have been discharged. That's possible.
In a proprietary context, that's right, my lord, yes, but not in a personal liability context. I mean, when one thinks of insurance claims, obviously one's being subrogated to the underlying negligence claim or whatever form of personal injury claim it might be. My lord, if one wants a reference for that, it is addressed in the Goff and Jones.
I think the Park Battersea case tells you can be subrogated to liabilities which have been extinguished, but they're deemed to continue for the purpose of subrogation.
But I think that's only.
Lord Hoffman who explains all this.
I think it's only in a proprietary context.
That may be right.
For what it's worth, the reference in Goff and Jones is chapter 1945. Obviously, that's the very recent edition of Goff and Jones, and it's
chapter
a text.
19.
Paragraph 45. And it talks about the 2 kinds of subrogation, so where there is a continuing subsisting obligation and then the deemed fictional type of subrogation. But here in my submission, we're not really looking at a subrogation claim. It is a claim in contribution or reimbursement. I think technically reimbursement because of the amounts involved.
Yes, well, we were looking at Andrews and Millett overnight and the night before, and they are quite clear that the guarantor's claim against the principal debtor is not a claim in subrogation.
Right. Is not a claim
in subrogation.
Oh, I'm grateful for that. My lord's ahead of me, and perhaps not for the first time. My lord, if that's right, that it's a claim in contribution or reimbursement that we're talking about, then it's a claim in unjust enrichment, restitution. It would have to have all the normal incidents of a claim of that kind. So you would need enrichment of the defendant at the expense of the claimant, some unjust factor and no defence, which is the quadrangle of factors one needs. Now, my learned friend said at page 130 of the transcript on day 2, lines 11 to 22, it's not clear why we're looking at chapter 20 of Goff and Jones. It expressed some surprise as to why I'd gone there and what the relevance of it all was. Well, for the reasons I've set out, it is the correct chapter. That's dealing with the right restitutionary claim that we would at least potentially be concerned with. But also that is the chapter that's expressly relied on by the LLP and by my learned friend in their skeleton argument. So in the one paragraph that this argument warrants, which is paragraph 42.3, if perhaps we could just go there quickly. It's paragraph 42.3, page 62 of the core bundle in tab 3.
Yes, they refer to
So,
paragraph.
I mean, that's the basis on which they put this alternative argument, that you look to a claim that's delineated in, and there is a lined margin passage against paragraph 2010. It's also where they get excellent partridge from, which is a case that's nothing to do with these circumstances, about distraining for rent of a carriage that a third party had left. But all of these cases come from there. So, I mean, clearly, that's why I'm referring to it, and that's why I took you to the passages that I did, which I'll come on to make my substantive points now, but that's why I was looking at those passages. 3 substantive responses to the restitutionary claim.
Well, I wonder if you want to make your substantive responses at 2 o'clock.
That would be very helpful, yes.
Right, 2 o'clock.
Court rise.